And the affidavit recites that the affiant has reviewed the Fair Health database, the Healthcare Blue Book, and the Context for Healthcare database, which are all databases based on private insurance, Medicare, and Medicaid. My guy doesn't have any of that. So we asked the court to strike that affidavit since it's based on Medicare rates, Medicaid rates, private insurance rates that are apples and apples in our particular case.
All right, response?
Your Honor, he's opposing counsel cited no authority or documentation to state that these databases are in any way unreliable references. He's made no argument that the counter affidavit failed to give reasonable notice, and no argument that my doctor's unqualified. This is a one paragraph motion to strike, and it's not a Daubert motion. So I believe it should be denied based on the fact that he is not making any arguments regarding failure to give reasonable notice, not making any arguments that Dr. Curry is unqualified. I would like to point the court to a couple of cases. One is the Gunn versus McCoy case. In that case, it's a Supreme Court case.
Let me just say this. I see so many of these motions these days, so I kind of try to be very consistent with them. And so let me kind of tell you the rubric I go through on this, at least until the Supreme Court or the legislature tells me I'm supposed to do something else. The first thing I do is I always strike billing clerks or, non-doctors basically. So that's not the situation here. So that's the first rubric. Then I look, is the treatment like to like? So a chiropractor under Turner v. Perel can counter a chiropractor, but not an orthopedic surgeon. And so they have to be like to like. And I think that's not an issue here either. So then finally I look at, are they comparing, apples to apples in terms of, if the gentleman doesn't have Medicare, Medicaid, or health insurance, and they're using Medicare, Medicaid, or health insurance as the measure, then I will typically strike that. And so I will say, Mr. Clark, your motion to strike is pretty bare bones. I see these all the time, and so I wasn't 100% sure where you were coming from. So I do agree with defense counsel that it's a little, she's kind of shooting in the dark a little bit here.
Judge, I received the reply to the motion on Friday, and then on Friday I wrote a letter to this court enclosing the top 2 pages from the Fair Health website that says we use this Medicare, Medicaid, whatever. So we're on the same page. She understands what my motion is about, and the Fair Health database or their website clearly says that's what they use. So we're in your third category of not apples and apples. That's why I asked the court to strike it.
Right. So let me look at the exact affidavit. So is that what she does? Is she using basically just the...
So page 12, paragraph 25. That's where the reference is to the 3 databases. And then you go over to page 16, and what they do is they take the databases, the high end, the low end, divide by the middle point, come up with their number. So it's all based on Medicare, Medicaid, and private insurance.
And I would like to add that it's not all based on Medicare and Medicaid. Dr. Curry, in his counter affidavit, he posits that his opinions that charges are unreasonable are not only based on those databases, but they're also based on his personal experience.
Can you just show me where he says that? What paragraph?
Yes, let me find it.
Judge, if the court please, we're waiting on that on page 12. On the first charge, Fair Health is 234, Blue Book's 304, context is 407. So he takes the three numbers from the three websites. And on page 16, he says the range is 234 to 407. The average is 315. So it's right mathematically from those three websites. It's not based on anything personal that he does. It's just review, high, low, in between, average.
He says on page, page 13, he says, well, page 12 and 13, he says that based on this analysis and my personal experience, the charge for a level 4 consult is unreasonable. Then he says, as far as follow-up visit, based on this analysis and my personal experience, the charge for a level 3 follow-up is unreasonable. He says it on just about every charge that based on his personal experience, and he's a board certified.
So what? Show me again where I'm. Let me share a screen so you can kind of direct me to where you're talking about.
So on starting on page 12 at the bottom, number 25,
Okay.
Continuing on to page 13. At the top of page 13, he says, based on this analysis and my personal experience, the charge for a level 4 consult is unreasonable. And then number 26, based on this analysis and my personal experience, the charge for level 3 follow-up is unreasonable. And then number 20, let's see. And then, yeah, on 29, he says the fee charged for this, in my professional opinion, is unreasonable.
So let me just kind of tell you how the affidavits that have generally survived, if they go through this whole rubric, is he has to do some type of analysis of, basically apples to apples comparison. And what I mean by that is he talks to people in the, in the legal, in the medical community in his area of specialty to do a determination of, this is what self-payers pay because this guy is a self-payer. Is that right, Mr. Clark?
Yes, correct, sir.
And so, it's not what somebody who has Medicare, Medicaid, or health insurance would pay because they have contractual adjustments. It's what somebody who is a self-payer would pay. And so to the extent I wasn't clear about that this would not be, what you've shown me so far would not be sufficient. So is there anything else you wanted to point me to?
Yeah, I just wanted to point out in that Gunn versus McCoy case that
I'm familiar with that case. I don't think it applies. And
there's another 12th Court of Appeals case in 2019 in Ray Brown. And
is that in the Tyler case?
Yes.
Yeah, I'm familiar with that case too. I don't mean to cut you off. I just hear so many of these things. I hear these arguments over and over again. I mean, you can make it again if you want to.
Yes, just that that court found the trial court's order granting a motion to strike the controverting affidavit from a nurse attacking only the reasonableness of cost was an abuse of discretion, and that the nurse was entitled to rely on her databases on medical costs when opining regarding whether charges were unreasonable. And, in Gunn versus McCoy, the Texas Supreme Court is saying that national and regional bases that compare prices that are actually paid by insurance companies make them well suited.
And Gunn is not in context of a counter affidavit, correct?
It's in the context of no insurance companies they regularly negotiate and use those databases. And they're saying that, essentially those databases, which use Medicare and Medicaid information, are valid sources, and that insurance companies are well suited to determine the reasonableness of those medical expenses. And translating that to here, I would argue that those same databases are acceptable, reliable sources to be used by experts in determining the reasonableness of medical expenses and costs in any given area.
All right, so the Corey affidavit is struck. Is there?
Wait, I do have, his motion is only as to the costs, the reasonableness of the costs.
Okay.
So he offers other opinions regarding necessity, and
Okay.
plaintiff's attorney has made no motion to strike
I agree.
those opinions.
I
So,
agree.
Mr. Clark, so how do you propose to deal with this then? If there's
If the motion is granted, this affidavit is stricken concerning his opinions as to reasonableness of medical charges.
then you'd still have to call your doctor, right?
You know, on my claims,
I think so, yeah.
I mean, I think the jury can, I think the jury can find necessity, but I can look at that later. But for
I mean,
today's,
what, I don't know how big this case is. What we do on a lot of the smaller cases is dueling affidavits. Is that something you guys have done before?
I don't agree. I don't want to do that, sir.
Okay.
If we can just strike the affidavit as to the reasonableness of the charges, go to our mediation and see what happens.
I would also like to add that I requested at the end of my response that I be given the opportunity to cure any defect.
Yeah, I don't ever allow that. And I shouldn't say that. I do allow it if there's let me just ask this. I have allowed that in situations where, for example, the plaintiff's attorney only provided the medical bills and not the medical records. So it wasn't, you weren't able to, the defendant wasn't able to really do a counter affidavit because they didn't have the medical records. Is that the issue here?
No, sir.
No, sir.
Okay. All right. So the motion's, he's struck as to the reasonableness. Is there a second affidavit I need to look at?
No, just one affidavit.
Just one affidavit. Okay. All right. So, Mr. Clark, go ahead and prepare a order for me as to striking as to reasonableness of charges, but not as to necessity, and share that with Engelman, and just and then email Rhonda, who's my court coordinator, as well as he followed. Okay.
I'll do it. Thank you, sir.
Good luck on your mediation, guys.
Thanks.
Actually, let me ask you one quick question before you go. When are y'all set for trial?
August.
So the newest that we've heard from our local administrative district judge is that we're going to be resuming trials, and this could change, but this is just what we've heard as of last couple weeks ago, and is going to start in August. At least initially, the thought is that we would be doing 6-person juries, and then eventually in October, we would go back to kind of a normal docket. I wouldn't suggest we change this trial until we know more definitively what's going to happen, but it's kind of up to y'all what you want to do. If you want to just keep it that date, or how you want to go forward.
Well, let's get through Friday, then we'll get back to the court.
I hope it works out, guys. You guys have a good day.
Thank you. You too, Your Honor.
Thank you. You guys are excused. Reverse Mortgage Funding LLC versus the unknown heirs of James Milan Monk. Anyone here on that case?
Joseph Osick on behalf of the plaintiff.
Is Mr. Griggs on this one?
Yeah, he's the court-appointed ad litem for the unknown heirs in Ren Berry Monk. Here's the issue with this. There's an order for substitute service signed for Ren Berry Monk, but I don't think that's going to accomplish anything, because looking at the affidavits again, the neighbor says he hasn't lived at his father's house in a very long time, and the property is actually vacant. That's the decedent's, house. So I had filed a motion for site by publication for Wren, Monk, and unknowns, but that hasn't been signed yet because of the subservice order that was signed previously. So
let me, I'm share screening this. Can you see it? Which order are you wanting me to look at?
the order of substitute service.
On
That- I
225?
Yeah, I think it would be best to strike that order because the property is vacant and the subservice order is for the property address. So I don't think it's going to accomplish anything.
Let me just look at this.
So
So you
No.
want me to vacate the previous, so that you want, there was an order signed on
yes, that order right
February
there.
5th. Okay,
Yeah.
so you want me to vacate that one and then
Do
sign
the
sign the
the
next one?
the site by pub.
See, it doesn't look like the whole affidavit is attached.
Okay, well, I can amend that today.
You see what I'm saying here?
I see what you're talking about. Yeah, it looks like it didn't get filed correctly, so I understand.
I mean, I think, don't you have to serve at the address though? I mean, you don't want to post on the address?
Well, is the substitute service order is just for Wren Monk, who's the decedent's son. If
Right.
the property is vacant, he's not going to get notice of the lawsuit if we just post it to a vacant property.
I mean, I'm saying you might want to do both.
Okay, we can do both.
Go ahead and get me a complete order here, a complete motion. Go ahead and email it to Rhonda as well as an order, and make sure it includes service by publication and by posting at the address. And we'll try to get that signed. Let me just see when you're set for DWAP next week. Do you want us to move that?
Yes, if possible. Yeah.
Rhonda, let me get this. We will go ahead and move this 60 days. Did she get that? Okay, she got it. All right, we'll move to 60 days. Try to get me an order in by the end of the week. Make sure you email Rhonda as well as e-filing it.
Will do. Thank you, Your Honor.
Thank you. You have a good day. Be safe, okay?
You too.
All right, our next one is a motion to compel involving David Nix involving Caitlin Gundy versus Dax Garman. For both sides here.
David Nix here on behalf of the plaintiff, Your Honor.
Nick Knowles for Mr. Garman.
Okay, it looks like there's two sets of defense attorneys, Robert Dorsett and Michael Hurst.
I'm with Mr. Dorsett's office.
And then what about anyone?
Your Honor, I'm here.
Oh, Mr. Hurst is here?
Yes, sir.
Okay. All righty. Let's go ahead and go on the record on cause number DC 2014539, Gundy v. Garman. Counsel, make your appearances.
David Nix on behalf of the plaintiff.
Nick Knowles for defendant Dax Garman.
Mike Hurst for defendant UFCC.
Okay, let's go ahead and proceed.
Thank you, Your Honor. This is Dax Garman, his motion to compel. We DWQ'd some medical records based on providers that plaintiff had provided in disclosures. We initially requested 10 years back. Allison, who is another attorney in our office, and Mr. Nix had an agreement for 5 years. The issue that we are facing now is Mr. Nix would like to review the records before they are produced to our office, and he wants to limit to the certain parts of the bodies that are complained of in the original petition. Our stance is that it's discoverable, it's relevant. It may not be admissible later at trial, but we don't think that we need to go through the process of having it ferreted out by plaintiff's counsel before it is produced to us, because it's, you know, we've done this in prior cases, and it ends up just being a more litigious, so to speak, experience where we end up back here to argue over objections and claim privileges, and it's judicial economy just for us to have the records, and with the understanding that not all of it is going to be admissible.
So let me tell you what I do. I'm very consistent. I've been doing this quite a while, and so on almost all cases, unless it's occasionally head injuries get a little more complicated, but in almost all cases, what we do is I allow 5 years prior to the accident, any treatment related to the accident, and then treatment post-accident, and for the same areas of the body. And then I also allow the plaintiff's attorney to review the records before they go to the defense attorney. And then if there needs to be some type of in-camera inspection by me, if there's some different disagreement about something, I do an in-camera inspection, and it's typically worked fine in my court. I've been doing this for 15 years. This is my 15th year on the bench. So I don't know if that's consistent with what Mr. Nix wanted or not, but that's kind of how I do it.
It is, Your Honor, and quite frankly, it's not been an issue with us. We've done this on many occasions as well. And all we were asking for was just 10 days after receipt from the record retrieval service. And we'll either turn the records loose at that time, or if we feel that we need to file some sort of privilege log, then do that. But
now, let me say one thing I'd probably do a little differently than you guys, other judges may. Though it's been a little more complicated with with Zoom, is that I usually do the in-camera inspection with the attorneys there, either in person. I guess I could do it over Zoom, though I haven't done it a lot over Zoom. And the reason for that is you guys are going to know more about the case than I do. So just be aware of that. If you do request an in-camera inspection, then I need to have a hearing on it. To kind of discuss, discuss the particular records I'm reviewing. So just kind of be aware of that for both sides. Mr. Nix, have you prepared an order that details all this, or do you?
I have not, but I will, Your Honor.
Okay. Anything else we need to chat about, guys?
No, Your Honor.
All right. I just try to be consistent in every case. So, don't feel bad that I may have done one thing or the other. So,
Thank you, Your Honor. I appreciate it.
You guys have a good day. Mr. Nix, try to get me an order as soon as you can. Make sure you run it by Mr. Knowles and Mr. Hurst before you submit it. Okay.
Absolutely.
All right. And when you do, if you could, this is just easier during COVID. If you could put the date that the hearing occurred. So like on March 22nd, blah, 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 the court made the following order or whatever. Don't just put on this date. It makes it easier for me to tie it back to the actual hearing. So if you could just include that in the order, that'd be great.
And Your Honor, just to be clear, it's not just the in-camera inspection, but in addition to that, the record retrieval is to limit it to the parts of the body pled in the petition. Is that correct?
Right.
Okay. All right. Thank you, Your Honor.
Thank you, guys. You guys be safe, okay?
You too. Thank you, Judge.
Thank you. All right. I think it's a little bit earlier. Both sides here in Lanahan Law versus Schultz.
Your Honor, Tom Coward for the plaintiffs. I do not, there he is. There's Mr. Mary, he's here.
It's early. It's early, so if there's somebody else that needs to be here or whatever, I'm not trying to rush it, but if everyone's here and ready to go, I can.
Ready to
We're
roll,
ready,
Judge.
Judge.
All right, let's go on the record. Tony, are you ready? On cause number DC 2018255, Lanahan Law versus Huffsey. Counsel, make your appearances.
Tom Coward for the plaintiffs, Linehan Law and Gonzalez and Gonzalez.
And Eric Marie for the defendant, Judge. I don't say that normally, but I'm gonna throw that one out there.
And let me just say this, you know, I knew Mr. Schultz. I think Mr. Schultz was an excellent lawyer, and I just want to express my deep sadness of his passing. He was a very passionate advocate for people who needed that, and I just have so much respect for him, and really grieve with his family for his loss. And so I just wanted to. It's not going to impact my rulings at all in this case, but it's something I think that needs to be said.
And Judge, I'll pass that along to Ms. Huffsey, who is Steve's daughter, and Ryan, that's his son. I think they'd really appreciate that.
Please do. I'd appreciate that. All right, let's go ahead and deal with this motion to transfer.
And Judge, yeah, this is my motion. I think it's pretty straightforward. The underlying case involved 2 deaths that was pending in Judge Greenberg's court for several years. Steve was brought in on the case by Nash Gonzalez, who is Gonzalez and Gonzalez PC. Steve handled the case for a time. They got up to, I believe they were about to start fact witness depositions, and Steve had done quite a bit of work on the case. And then he got sick. And when he got sick, it wasn't like a period of time. It was immediate. It was, hey, I don't feel so good. And then he was out for about 3 months. He was totally in a coma. When he came out of the coma, this is the first case that he asked me about. And what had happened in the meantime was Mr. Gonzalez took the file from Steve's office and brought it to Linehan to prosecute, which we're not arguing at this point. We're only asking for quantum merit on behalf of Steve and what he had done, the value of his work prior to him getting sick. And so the file was transferred. Steve authorized me to file an intervention on his behalf in County Court of Law number 5. And so there was a prior action pending in County Court of Law number 5 for the attorney's fees, which was voluntarily non-suited prior to final judgment. And so we're arguing 3 bases for this transfer, Judge. 1.03, which I think they argue there's no pending matter, and I kind of agree with that. The matter is not really pending in County Court at Law number 5 anymore. It's on appeal, and so I'm not sure what the status of the appeal is. I'm sure Tom knows more than me. But certainly under 1.06 local rule, which talks about related cases, which would facilitate orderly and efficient disposition of the litigation, and more particularly under 1.07, which doesn't require, but urges transfer if the earlier case was dismissed by the plaintiff before final judgment. And that's exactly what we have here, Judge. We dismissed our claim for attorney's fees in Judge Greenberg's court, or it would still have been pending there. And Judge Greenberg would be listening to this while the case the prior case was extended. Unfortunately, what happened instead is they settled out with one of the main defendant, and then Judge Greenberg granted summary judgment on a remaining defendant, and they've appealed that. And so obviously the plaintiffs in this case jumped out and filed a lawsuit in district court instead of in county court, where it probably would have ended up in Judge Greenberg's court no matter what. So from my perspective, Judge, I have a great relationship with you. I have a great relationship with Judge Greenberg. I could care less at this point where it goes. But I think given the amount of work that was done in front of Judge Greenberg and that the prior case was there and that we had already filed a request for our attorney's fees, which we voluntarily non-suited, I think that the argument is in our favor of moving the case to back to county court of law, number 5.
Can I just say one